All right, so I decided to read this and possibly post this because this could help somebody. Or if you just like listening to things, depending on how good this goes, we may turn it into a series and I may actually spend some money and get an actual mic. But for the time being, I am recording on my iPhone. So please enjoy. We are reading from Black's Law Dictionary, Revised 4th edition. I don't know Roman numerals, but we're reading from page XLIV. We're in the Code of Professional Responsibility, and I am starting from Ethical Consideration 5-3, and I will now begin. The self-interest of a lawyer resulting from his ownership of property in which his client also has an interest or which may affect property of his client may interfere with the exercise of free judgment on behalf of his client. If such interference would occur with respect to a prospective client, a lawyer should decline employment proffered by him. After accepting employment, a lawyer should not acquire property rights that would adversely affect his professional judgment in the representation of his client, even if the property interests of a lawyer do not presently interfere with the exercise of his independent judgment, but the likelihood of interference can reasonably be foreseen by him. A lawyer should explain the situation to his client and should decline employment or withdraw unless the client consents to the continuance of the relationship after full disclosure. A lawyer should not keep to persuade his client to permit him to invest in an undertaking of his client, nor make improper use of his professional relationship to influence his client to invest in an enterprise in which the lawyer is interested. Ethical Consideration 5-4. If in the course of his representation of a client, a lawyer is permitted to receive from his client a beneficial ownership and publication rights relating to the subject matter of the employment, he may be tempted to subordinate the interest of his client to his own anticipated pecuniary gain. For example, a lawyer in a criminal case who obtains from his client television, radio, motion picture, newspaper, magazine, book, or other publication rights with respect to the case may be influenced consciously or unconsciously to a course of conduct that will enhance the value of his publication rights to the prejudice of his client. To prevent these potentially differing interests, such arrangements should be scrupulously avoided prior to the termination of all aspects of the matter giving rise to the employment, even though his employment has previously ended. Ethical Consideration 5-5. A lawyer should not suggest to his client that a gift be made to himself or for his benefit. We're going to read that again. A lawyer should not suggest to his client that a gift be made to himself or for his benefit. If a lawyer accepts a gift from his client, he is peculiarly susceptible to the charge that he unduly influenced or overreached the client. If a client voluntarily offers to make a gift to his lawyer, the lawyer may accept the gift, but before doing so, he should urge that his client secure disinterested advice from an independent, competent person who is cognizant of all the circumstances. Footnote 3. Quote, courts of equity will scrutinize with jealous vigilance transactions between parties occupying fiduciary relations toward each other. A deed will not be held invalid. However, if made by the grantor with full knowledge of its nature and effect, and because of the deliberate, voluntary, and intelligent desire of the grantor, where a fiduciary relation exists, the burden of proof is on the grantee or beneficiary of an instrument executed during the existence of such relationship to show the fairness of the transaction, that it was equitable and just, and that it did not proceed from undue influence. The same rule has application when an attorney engages in a transaction with the client during the existence of the relation and is benefited thereby. Conversely, an attorney is not prohibited from dealing with his client or buying his property, and such contracts, if open, fair and honest, when deliberately made, are as valid as contracts between other parties. Important factors in determining whether a transaction is fair include a showing by the fiduciary: 1. That he made a full and frank disclosure of all the relevant information that he had. 2. That the consideration was adequate. And 3. That the principal had independent advice before completing the transaction. End quote. McPhail versus Braden, 19 ILL, period 2D 108, comma 117-18, comma 166, en.e2d space 46, comma space 52, open parentheses 1960, close parentheses, period. Okay, let's see where we were. Other than in exceptional circumstances, a lawyer should insist that an instrument in which his client desires to name him beneficially be prepared by another lawyer selected by the client. Footnote 4. See State Ex Rel, Nebraska State Bar Association versus Richards. Alrighty, ethical consideration 5-6. A lawyer should not consciously influence a client to name him as executor, trustee, or lawyer in an instrument. In those cases where a client wishes to name his lawyer as such, care should be taken by the lawyer to avoid even the appearance of impropriety. Footnote 5. See ABA Canon number 9. Ethical consideration 5-7. The possibility of an adverse effect upon the exercise of free judgment by a lawyer on behalf of his client during litigation generally makes it undesirable for the lawyer to acquire a proprietary interest in the cause of his client or otherwise to become financially interested in the outcome of the litigation. Footnote 6. See ABA Canon 10. However, it is not improper for a lawyer to protect his right to collect a fee for his services by the assertion of legally permissible liens, even though by doing so he may acquire an interest in the outcome of the litigation. Although a contingent fee arrangement gives a lawyer a financial interest in the outcome of litigation, a reasonable contingent fee is permissible in civil cases because it may be the only means by which a layman can obtain the services of a lawyer of his choice. But a lawyer, because he is in a better position to evaluate the cause of action, should enter into a contingent fee arrangement only in those instances where the arrangement will be beneficial to the client. Ethical consideration 5-8. A financial interest in the outcome of litigation also results if monetary advances are made by the lawyer to his client. Although this assistance generally is not encouraged, there are instances when it is not improper to make loans to a client. For example, the advancing or guaranteeing of payment of the costs and expenses of litigation by a lawyer may be the only way a client can enforce his cause of action. Footnote 9. We skipped footnote 7 and 8 because they just reference American Bar Association canons. Footnote 9. Rule 3A. A member of the state bar shall not directly or indirectly pay or agree to pay or represent or sanction the representation that he will pay medical, hospital, or nursing bills or other personal expenses incurred by or for a client, prospective prospective or existing, provided this rule shall not prohibit a member, 1, with the consent of the client from paying or agreeing to pay to third person such expenses from funds collected or to be collected for the client, or 2, after he has been employed from lending money to his client upon the client's promise in writing to repay such loan, or 3, from advancing the cost of prosecuting or defending a claim or action, such costs within the meaning of this subparagraph 3 include all taxable costs or disbursements, cost or investigation of cost of obtaining and presenting evidence. Cal Business and Professions Code, subsection 6076, West Sup, 1967. Alrighty. So we're going to start back from the middle of ethical consideration 5-8. For example, the advancing or guaranteeing of payment of the costs and expenses of litigation by a lawyer may be the only way a client can enforce his cause of action, but the ultimate liability for such costs and expenses must be that of the client. Ethical consideration 5-9. Occasionally, a lawyer is called upon to decide in a particular case whether he will be a witness or an advocate. If a lawyer is both counsel and witness, he becomes more easily impeachable for interest and thus may be a less effective witness. Conversely, the opposing counsel may be handicapped in challenging the credibility of the lawyer when the lawyer also appears as an advocate in the case. An advocate who becomes a witness is in the unseemly and ineffective position of arguing his own credibility. The roles of an advocate and of a witness are inconsistent. The function of an advocate is to advance or argue the cause of another, while that of a witness is to state facts objectively. Wow. That's worth reading again. The roles of an advocate and of a witness are inconsistent. The function of an advocate is to advance or argue the cause of another, while that of a witness is to state facts objectively. Ethical consideration 5-10. Problems incident to the lawyer-witness relationship arise at different stages. They relate either to whether a lawyer should accept employment or should withdraw from employment. Footnote 10. When a lawyer knows prior to trial there will be a necessary witness, except as to merely formal matters such as identification or custody of a document or the like, neither he nor his firm or associates should conduct the trial. If, during the trial, he discovers that the ends of justice require his testimony, he should, from that point on, if feasible and not prejudicial to his client's case, leave further conduct of the trial to other counsel. If circumstances do not permit withdrawal from the conduct of the trial, the lawyer should not argue the credibility of his own testimony. Code of Trial Conduct, promulgated by the American College of Trial Lawyers. 43 ABA J 223, 224-25, open parentheses 1957, close parentheses, period. Regardless of when the problem arises, his decision is to be governed by the same basic considerations. It is not objectionable for a lawyer who is a potential witness to be an advocate if it is unlikely that he will be called as a witness because his testimony will be merely cumulative, or if his testimony will reduce only to an uncontested issue. Footnote 11. CF Canon 19. When a lawyer is a witness for his client, except as to merely formal matters, such as the attestation or custody of an instrument and the like, he should leave the trial of the case to other counsel. End footnote. In the exceptional situation where it will be manifestly unfair to the client for the lawyer to refuse employment or to withdraw, when he will likely be a witness on a contested issue, he may serve as advocate, even though he may be a witness. Footnote 12. It is the general rule that a lawyer may not testify in litigation in which he is an advocate unless circumstances arise which could not be anticipated, and it is necessary to prevent a miscarriage of justice. In those rare cases where the testimony of an attorney is needed to protect his client's interest, it is not only proper but mandatory that it be forthcoming. Schwartz versus Wagner, 267 MIN.40, 43-44 124N.W2D 489 492, open parentheses 1963, close parentheses, end of footnote 12. In making such decision, he should determine the personal or financial sacrifice of the client that may result from his refusal of employment or with withdrawal therefrom, and materially of his testimony, and the effectiveness of his representation in view of his personal involvement. In weighing these factors, it should be clear that refusal or withdrawal will impose an unreasonable hardship upon the client before the lawyer accepts or continues the employment. Footnote 13. The great weight of authority in this country holds that the attorney who acts as counsel and witness in behalf of his client in the same case on a material matter, not of a merely formal character, and not in an emergency, but having knowledge that he would be required to be a witness in ample time to have secured other counsel and given up his service in the case, violates a highly important provision of the Code of Ethics and the rule of professional conduct, but does not commit a legal error in so testifying, as a result of which a new trial will be granted. Aaron M. Jennings Co. versus DiGenova. End of footnote 12. No, I'm sorry. End of footnote 13. Where the question arises, doubts should be resolved in favor of the lawyer testifying and against his becoming or continuing as an advocate. Footnote 14. Cases may arise, and in practice often do arise, in which there would be a failure of justice should the attorney withhold his testimony. In such case, it would be a vicious, professional sentient which would deprive the client of the benefit of his attorney's testimony. Connolly versus Straw. But see Canon 19, except when essential to the ends of justice, a lawyer should avoid testifying in court in behalf of his client. That is end of footnote 14. I'm going to stop this now. This is already 18 minutes. If you enjoyed this, please leave a like, comment, and subscribe below. In the description of this video, there should be a way for you to contact me if for whatever reason you need to do so. Have a blessed day and shalom. Thank you for listening.